I'm calling this conference committee to order. Representative Carlos Mariani, chair of the Minnesota House Conferees. I am joined today with my my House Conferees, although I must say, I think Representative Miller is here. I know he's got some pressing things, so I think Representative Miller, you're going to be perhaps in and out a few times, but just alerting folks of that.
Yep, thank you, Chair. Yes, I will be in here for as much as I can. Thank you.
Glad you're with us, Representative Miller. And then, of course, joined by my colleague, Chair Warren Limmer, and his colleagues. And so a couple of things just to say up front. This hearing is being held according to both House and Senate rules. In the House, it's House Rule 10.01. I'm not sure if those are the same rule numbers in both bodies now. But basically it allows us to have hearings in an electronic platform, digital platform, in observance of the COVID pandemic need for social distancing. The public can view that rule on our respective websites, as well as to visit those websites for instructions on how to access these proceedings via streaming video. It's really important to both House and Senate that we do our work in the light of transparency for the public to follow along. Senator Limmer, perhaps if you would be so kind just to have your members introduce themselves. I'll do the same, just so everyone in the public knows who's here today.
Thank you, Chair Mariani. I'm Warren Limmer. I'm state senator from the Northwest Hennepin County area and the chairman of the Judiciary and Public Safety Committee in the Senate. Why don't we move on to Senator Ingebrigtsen, and then Chair Mariani, why don't you make the formal lead in, and then I'll sit back as you introduce members.
Chair Mariani, thank you. And thank you, Chair Senator Limmer. Senator Bill Ingebrigtsen from Senate District 8, West Central Minnesota, Alexandria, Fergus Falls, Perham, in West Central part of Minnesota. I'm on the Judiciary Committee. Thank you.
Very well, welcome. Senator Matthews, I believe.
Senator Matthews is on his way,
Okay.
Chair Mariani. Maybe by the time we get to the end, he'll appear.
That's quite all right. And so is Senator Latz here?
Yes, good afternoon. Ron Latz, Senator from St. Louis Park, represent St. Louis Park, Hopkins, parts of Golden Valley and Plymouth and all of Medicine Lake, first and second ring suburbs west of Minneapolis. And I'm the DFL lead on the Senate Judiciary Committee, and I also serve on the Senate Civil Law Committee.
Good to see you, Senator. And then who am I missing in the Senate? I'm blanking pretty quickly here.
Chair Mariani, this is Senator Mark Johnson here.
Senator Johnson, my apologies to you, sir.
No problem. So I'm Senator Mark Johnson, represent Northwest Minnesota, bordering on Canada and North Dakota, and I am vice chair of the Public Safety Committee. Thank you very much.
Very well. Good to see you. On our side, we've got Representative Frazier.
I have to find that mute button. Thank you, Mr. Chair. Representative Frazier, District 45A, which is in the northwest suburbs, representing the cities of Crystal, New Hope, and the eastern part of Plymouth, and vice chair of the Public Safety Committee.
And we also have our chair, Representative Becker Finn.
Yep, Jamie Becker Finn.
I'm sorry.
Yep, Jamie Becker Finn, chair of the House Judiciary Committee.
All right, and we have Representative Bowler.
Thank you, Mr. Chair. Representative Kelly Muller, Vice Chair of the Judiciary Committee.
Very well. And we heard earlier from Representative Miller.
Yes, Chair Mariani, thank you. District 17A.
Very well. And if you do need to hop out, feel free, and I'm sure you'll jump back in when you're able to as well. All right, members, just some housekeeping things quickly before we get into today's agenda. One, just to alert that when we have the gavel, the House has the gavel on Saturday, we're going to be taking up prison safety and corrections reform issues. Today's agenda is focused on legislative proposals to improve our systems for good policing. I'm sure everyone knows policing issues are a front and center issue in Minnesota and the United States, and action is taking place everywhere. And here in the state, where we had an officer murder, George Floyd, and a simple traffic stop recently led to the killing of Devontae Wright, it's important for this state's legislature to take common sense action that makes for safer conditions for communities and lifts up better police action and strengthens our communities. And so today we're going to hear from people. The House has invited several people to come and speak briefly on the impact that deadly force in policing has had on their lives, as well as other policing actions that have led to harm in their lives or the lives of their clients and loved ones. It's the House's position that the call for change is strong and that call is for action now, which is why our Omnibus bill brings in a number of proposals for the Senate to entertain. I want the Senate to know that the House can negotiate on any and all of these with our Senate counterparts, but we want to impress the need to do something now and to provide the Senate with a sincere reason to act independent of partisan or inter-House dynamics. So that'll be today's agenda. Two things before then. One, I just want a quick inquiry of the Senate. We did put an offer on the table of same and similars 2 days ago. So a quick update on where the Senate is at would be helpful at this point.
Thank you, Chair Mariani. On your first offer, that was 7 or 8 elements that we've been reviewing in the last few days. I would want to remind the conference committee that those are all pure policy in regards to this budget bill. It happens to be all civil law subjects. And so as a result, I'm going to have Chair Andrew Matthews give the response due to the fact that he's the chairman of the Civil Law Committee.
Very well, Senator Matthews, Chairman Matthews.
Thank you, Mr. Chair. Thank you, Senator Limmer. So reviewed these provisions, went back with staff. We may get to a point with some of these, but at this point need to point out that about 5 or 6 of the provisions on this list are items sitting on the House floor. 2 of them, item 2, the Long and Johnson bill on uniform probate code, passed the Senate 67-0 on February 4th. That's ready for passage and could be on the governor's desk right away. The DNR minors bill also passed 67-0 on March 11th. So we got to keep working through in the overall context of what this bill will look like. But as we went down the list, most of these provisions are sitting on the House floor, and some of them are ready to go right to the governor for his signature right afterwards. So that's what I wanted to encourage the House after reviewing this list. And then we're going to have to keep working forward as we get targets, get the bills put together, and then figure out what provisions will get added after that.
Well, Senator Matthews and Chair Limmer, and to my Senate counterparts, that's kind of a new standard, I have to say, if one is perhaps being asserted that Omnibus conference committee should wait for all bills to make it off their respective bodies. We could be here for months if that's the standard. However, that is the prerogative of the Senate to either refuse or accept or counteroffer an offer just as it is with the House. I would certainly hope to see a counteroffer. What we structured was a pretty simple set of same and similars to get us into the groove of getting our work done. As we sit today, we're 11 days away from concluding this legislative session, which practically means, in practical terms, we probably have about 8 days, maybe 9 if we push it, to get to agreement and structure, that agreement in a way that can then be heard in both of our bodies, and not to mention to have the executive branch, offer their opinion on it as well, and to do that in a real transparent way. And so the way, the way I think we can best do this is to start moving on things that are not terribly complicated. We're talking about language that the Senate has. This is pretty common practice historically in this legislature. We've got committees right now that have already agreed to same and similar. So there's nothing radical or mysterious or kind of gotcha here whatsoever. This is really about trying to get our work done, and the House is quite serious about meeting the people's expectations to get our work done by the 17th of this month. And so I would urge my Senate colleagues to revisit their current looking at these simple same and similars, and if nothing else, offer us something in return, or rather offer a counter offer, I should say, in return. And as for policy, that's what we can do right now. We don't have targets. We can't work on, we can actually, but it's smarter to wait until our leaders get to a point of agreement on our fiscal parameters, and then we can move confidently with those. But we can certainly move confidently on the other provisions in this bill. And again, that's custom and usage in this body, or rather among us. Members, I do want to move forward. I'm going to call on Chair Becker-Finn, then Senator Matthews, and then we're going to move forward with this agenda.
Thank you, Mr. Chair. And I just want to clarify a couple things. There were 8 provisions. We really did consider this a good faith, really easy things that we should be able to get done quickly. And only 2 of those are things that are on the general register. So I would not characterize 2 as most of the provisions. And, if those 2 things passed unanimously, those should be easy things to agree to, would be, my response to that. As well, I just wanted to clarify, there were kind of 2 different comments made. First, Chair Limmer correctly stated that these are pure policy, but then, the excuse was made, well, let's wait until we get a target. And we really don't need to wait for a target because they are pure policy. And I would hope that we can move forward on things like this. There are even bigger issues where I think we can reach agreement if there is willingness to get to agreement. If we can't agree on the easy things that have already made it to, your second reading in the Senate, and things that are carried by Senate Republicans, it's a little frustrating. We started with an easy, small offer and would just really appreciate a true response to that offer. Thank you.
Very well. Representative Matthews, or rather Senator Matthews.
Thank you, Mr. Chair. And just to clarify, no, I'm not suggesting any new standard. We did go through these item by item, and let me expand a little. I neglected a couple of these other provisions are also under consideration in other omnibus bills that we've got to work out, where it will end up going. One bill, the other bill, both bills. So there's a few more points on that, but we did review this list, went over, we had several of them that did pass off the Senate floor, and likely, hopefully would also be pretty unanimous votes off of the House floor as well. Others moved through committees. So not stating a brand new standard going forward, took these items by items. And we're gonna keep working on a number of issues on our side. I do take this agreement or this offer for what you presented it. And we'll keep working on it, but wanted to highlight where the status of some of these provisions are at.
Very well. Thank you, Senator. Senator Johnson.
Thank you. Are we done with this topic right now? I just want to switch it briefly.
We do have an agenda, Senator Johnson. We could add something to the end of the agenda if you want to And
This is just briefly procedural on the front end. I know on Tuesday we mentioned it shortly, but there is a GOP House staffer that I would like to include on the call. Has that been worked out yet?
Senator Johnson, as I responded to Senator Matthews the other day, it's this chair's opinion it's unseemly for the Senate to interject themselves in House matters. I would think it'd be unseemly for us to do that with the Senate as well. I have publicly signaled that any such member can certainly contact me. I'm not going to get involved in making decisions for our minority caucuses. We have two, as you know, in the House. So that's for them to sort out, not for this chair to sort out. Thank you.
If I may, on that, I understand that this is the House's issue, and I'm not asking to get involved with that. However, this is a joint committee in which the outcome is very important for both you and me and the rest of the state. And if we're alienating the majority minority party, it worries me that we are going to have some greater hurdles. We're making some greater hurdles for this committee and for this bill. And so I just want to bring that up that you run the House how you need to run the House. But I think as far as the outcome of this bill is concerned, we probably will need some of those votes. So to me, I'm concerned that if we're trying to alienate that group, that we're going to miss some of that opportunity to really improve Minnesota's justice system. So that's why I want to bring it up, and I hope that we can resolve this issue.
Well, Senator Johnson, again, that's a matter for the House to resolve and not for this conference committee or the Senate to resolve. But I do join you in your call to make sure that we actually spend productive time here and that we get to an agreement before May 17th. A good step on the part of the Senate in this part would be to respond to the offer that we put on the table and to know that the House is ready to entertain offers as well, so we can continue to construct this omnibus bill in a timely manner. Members, I do want to move on. Vice Chair Fraser.
Just quickly, I hear this conversation going back and forth, and I just hope we're not providing other excuses or reasons not to negotiate and get things done for all Minnesota. So just wanted to put that out there.
Very well. All right, members. The next thing to share is that the House, in the spirit of trying to keep things moving, will in fact be putting an offer. We've already posted it publicly on the table at the end of this hearing, particularly on the issue of improving our systems for good policing. And so we structured the conversation today in order to provide some stronger background and urgency for this conference committee to work on, or rather to act on. We've structured that conversation in a way where we'll have general words of advice and speaking to the issue of why these issues should be worked on, agreed to, acted on rather, and done so at this point. And then we'll walk through very specific testimony on the very specific bills that the House will be offering today. And I've asked my Vice Chair, Representative Fraser, to walk through those bills in particular. But this testimony will be structured around that offer. And so the first part, as I mentioned, is to take general testimony on the need to act by stakeholders. And we're going to do this in two batches, if you will. We're going to hear from three individuals, and then we'll pause for any questions, discussion, comments by any of the conferees. And so first, we're going to hear from Kathy Waite, who is the Deputy Chief of Investigations at the Minneapolis Police Department. Welcome, Officer Deputy Chief Waite, to the committee. Please state your name for the record and provide us with your testimony.
Good afternoon. Can you hear me all right?
Yes, indeed.
Excellent. Thank you. Good afternoon, Chairs Mariani and Limmer and members of the conference committee. Thank you for this opportunity to comment today. Again, my name is Kathy Waite, and I have the honor of serving as the Deputy Chief of Investigations for the Minneapolis Police Department. My tenure here with the Minneapolis Police Department spans almost 30 years, of which I've filled multiple roles and have had the honor to work with the dedicated men and women of the Minneapolis Police Department. Chief Arredondo sends his sincerest regards to all of you, and your work has been very deliberate, and he looks forward to hearing more about that. It's been quite meaningful for public safety reform, and he wishes you well in the next week and a half as you meet. As law enforcement officers, my colleagues and I have a unique role of enforcing laws set by this state legislature. Thank you for the work you've done to promote public safety and community safety, ensuring that our state is the safest place to live for all of Minnesota. Last summer, the legislature answered calls from the community to assess the areas of law that would increase police accountability and promote trust between officers and the people that we serve. Those requests continue to be made, and I advise the legislature to find agreement on these bills. The Minneapolis Police Department is committed to working with you to improve how we do our job as police officers. The state does have a role to ensure reform is experienced statewide. The Minneapolis Police Department is supportive of public safety reform and is ready to participate in conversations regarding reform measures outlined in this omnibus bill. Specifically, MPD would like to express its support for the funding for new and continued training for peace officers included in both of these bills. By funding this training, you provide the financial support needed to ensure local law enforcement officers are provided with the opportunity to receive the very best training. This training is extremely important and continues to build upon positive interactions with every culture within our communities that we serve. Much of the proposed changes related to no-knock warrants that has been included in the House bill. They're already in alignment with what we are doing here in Minneapolis, and we've already adopted them into policy. MPD supports the proposed update to the bias crime statute. The development of new training for peace officers related to this statute should also be supported financially. The proposed changes will allow law enforcement the ability to ensure those who commit these crimes are held accountable for their actions. Lastly, we support the proposed reporting requirements related to the duty to intercede bill. We do not believe the suggested reporting requirements that are being asked to be made to the post board would be an onerous one for the MPD. Providing a safe community for all is the goal of MPD and our peace officers. We are committed to improving trust between community members and the police officers and looking forward to working with this committee and others to achieve this goal. Thank you so much for your time today, and I appreciate all of the considerations being made. Thank you so much.
Thank you, Deputy Chief Wade, and thank you for your work serving the people of Minnesota in public safety.
Thank you so much.
Next, we have Theodore Rose, Legislative Policy Director, Council for Minnesotans of African Heritage. Welcome to the conference committee, Mr. Rose. Please state your name for the record. Give us your testimony.
Yeah, thank you, Chair Mariani. For the record, my name is Theodore Rose, Chair Mariani, Chair Limmer, and members. I serve as the Policy Director at the Council for Minnesotans of African Heritage. Our council thanks you for the opportunity to testify before you today on the need for action on human rights and police accountability reform. Our state desperately needs this committee and the broader legislative body to unite and to pass proposals that would advance human rights and racial equity in our justice and policing systems. I want to express our council's support for the effort that is underway to build common ground. We think it's incredibly important that we pass police accountability legislation before the session ends. But first, I want to share our council's disappointment on what we think is the big elephant in the room. Like, we just got to address the big elephant in this virtual room. The fundamental truth facing this conference committee is that the justice and policing reform proposals that are on the table are not enough. For the past 12 months, Minnesota has been at the center of a national and global movement for human rights and police accountability. The Floyd uprisings and their aftermath have reshaped the moral compass of the early 21st century by centering racial disparities in the policing systems as objects of global outrage. Two things are very clear about this movement. The first thing is that the movement has inspired all kinds of innovative proposals for common sense improvements of our justice and policing systems. From the community standpoint, the policy changes being discussed today are less than the least you can do. People of African heritage and other communities of color have called for much more than this, and they've done the tedious and thankless civic work of regularly bringing police reform measures to the attention of the legislative body. The second thing to know about the movement for human rights and racial equity currently is that Minnesotans have led this global movement for change. The call for change is not a foreign thing. It is a Minnesotan thing. The people at the front lines of the movement to change our standards and raise our expectations for civil rights protection are regular, everyday Minnesotans. They're young people who attend our Minnesotan schools. They're families who live in our neighborhoods. They're workers and entrepreneurs who power our economy. People of African heritage and other communities of color across our state have organized, they've marched, they've called and written our council and the legislative body to express that they have a different experience with law enforcement. I'm not just referring to residents in the metro area, I'm talking about people in rural and greater Minnesota as well. From Moorhead to Rochester, Duluth, Faribault, everywhere in between. Minnesotans expect that their state bodies and leaders should act to ensure that all Minnesotans, including our BIPOC communities, receive equal protection under the law. We at the council have acted by working with community partners to bring the proposal for First Amendment protections to the Post Board. The Post Board has acted for the first time absent legislative direction to establish policies that respond to police misconduct and advance human rights protections. Very importantly, whether by coincidence or divine intervention, the Post Board took these important steps on April 22nd, the day of Daunte Wright's funeral. Now it's time for the legislative body and for you all to act. This conference committee can take action today by agreeing to move forward with common sense reform proposals that have received bipartisan support in the body. Both chambers should come together and agree to do at least the following. Require that officers report when excessive force is being used by other officers. Limit certain traffic stops that don't make communities safer. Require sign and release warrants to reduce traffic stop tensions and allow officers to focus on more important work. Place reasonable limits on no-knock warrants. Upgrade our state's tools for collecting data on bad officers, and empower families by requiring the release of body camera recordings within 48 hours of deadly force incidents. These aforementioned proposals have bipartisan support, they received bipartisan support in the body this session, and they are also supported by a diverse set of stakeholders, including law enforcement. We just urge you to take the bold step forward in transformative change towards human rights and police accountability reform. We thank you.
Thank you, Mr. Rose, and my appreciation to the council and its interactions and work with our Post Board as well. Next, we have Brian Fulman, founder of the Barbershop and Black Congregation Cooperative, and an Isaiah member. Please come forward, Mr. Fulman, state your name for the record, give us your testimony.
Thank you, Chair. My name is Brian Fulman. And so I just want to, what are we doing? When I think about the provisions, when I think about the sacrifices, as me as a grassroots organizer has made, what our community has made, our brother who just got through talking, the sacrifices he has made, our sisters has made, to actually lead people to these different committees, sacrificing their time, their wages, impacted folks, telling you exactly the harm and the targeting and the impact, how that's devastated them, how it's devastated their lives, the families. What else do we need? Where is the urgency? We're sitting on this call talking about the alienation of staff, but look at the alienation of the community. I think we need to understand that all the provisions that have been provided, politics is about negotiation. If there's an offer that has been provided, then where is the offer back? If we say that we want to fund our lives and we prioritize every life in the state of Minnesota and ultimately the country, then how are we modeling that? What I feel as a Black man in this state is the devaluing of not just me, but my family members. How do we get to have the luxury to continue talking about, oh, we'll get to it. Oh, we'll get to it. And we literally have lives that are out here who are being targeted. People who live with stress every day from being hunted. I'll tell you this. If there was a provision, a bill that actually went in law when we're limiting the misdemeanor and petty offenses around traffic stops, Philando is here. Durante Wright is here. If we talk about community oversight and we have real responsibility and accountability and the power given to community to be able to speak out and talk about the history and the transparency of the infractions, consistent infractions of police officers, there's no Chauvin kneeling on George Floyd's neck. I just do not feel the urgency from you all to get something done. Where is the negotiation? It has been a total dismissive attitude and behavior by the Senate to actually sit down and exercise democracy the way it's supposed to be. And that's actually roll up your sleeves, get into a room and discuss. People are not just dying by the hands of the police, they're dying with the ideology that it can happen to them. This needs to be prioritized. We are not putting forth the effort that is needed to make sure we have some kind of documentation that can go into law to start having more of a transparency and accountable relationships with the police departments across this state. I feel disrespected. I feel undervalued. How do I make meaning with communities who are disenfranchised, who don't have the platforms that's been afforded to me, who don't have the resources? How do I make meaning to them that government works? How do I speak life and hope into the hopeless when all we're doing is pushing back the bar, pushing back the standard? We need to stop ignoring what needs to take place. And we need accountability in different ways. And I won't waste any more time talking about the specific provisions. The proposals are there. They're clear. Where is the offer? How are you funding all of our lives? If Black lives matter, if all lives matter, then how are we actually making that legible to the society and the public of this state? How are they able to read that? Because they're not in this room. So I ask you all one more last time, let's get out of our own way. Let's stop being concerned about every political implication and start looking at the lives of our brothers and sisters, not as stats on paper, but real human life. Thank you.
Thank you. Thank you, Mr. Fulman. Next, we want to hear from the families of George Floyd and Dante Wright. They do have their representatives with them as well. And so I'll leave it to the families in terms of how they want to come forward. We have Brandon Williams, who is the nephew of George Floyd, I believe, nephew, as well as Katie Wright, who is the beloved mother of Dante Wright. Either one of you can come forward and certainly invite your representatives to join you as well.
Well, this is Jeff Storms. I'm one of the attorneys for both the families of George Floyd and Dante Wright. We can, I know Katie Wright is prepared to provide some testimony, and if Katie is prepared, she can go ahead and start now. She's identified on the screen through my associate, Christopher Scott. And I know Adner is also here from Ben Crump's office, and I believe Brandon Williams will be on as well.
He's on.
Okay, is there anyone else, Adner?
He will speak for the Floyd family.
Okay, thanks, Adner. Katie, if you want to go ahead.
Okay, thank you. Hello, everybody. My name is Katie Wright. On April 11th, my son Dante Wright was shot and killed by the Brooklyn Center Police Department, by the Brooklyn Center police officer. Dante was my baby, and he was an amazing kid. He was loving, he had a big heart, his smile could light up the room. He loved to play basketball, and he was funny. He loved to make jokes. He loved us and his brothers and sisters, and most of all, he loved his son Dante Jr. more than anything. He always told us that he wanted to be the kind of dad that would make Junior proud. He was taken from us and from all of those who knew and loved him. Losing him was honestly just felt like my heart was being pulled out of my chest. I would give anything to not be standing here today before you, to have Dante walk back through my door. But I'm here today to speak out in support of the bills before you today. Being the parent of a Black son means having to give them the talk, preparing them for interaction with police and how to leave it safely. It's terrifying sending your child into the world knowing that police may consider him suspicious simply for the color of his skin. I know that he was afraid of the police. What happened to him was truly a nightmare for our whole family. Despite all the talks, nothing could ever prepare him for any of us for how suddenly this happened. One of the last things that my son ever did was call me to tell me that he was being pulled over and to ask what he should do. He was scared. He was just a kid. He told us that he was stopped because he had air fresheners hanging from his rearview mirror. That stop resulted into his death only minutes later. That no person should ever have to die over something so small. One bill before you today would keep police officers from being able to stop and detain for simple car equipment violations. Things like blinkers, windshield wipers. Another would allow for greater civilian interaction with oversight of policing. These bills will make our community safer and decrease unnecessary interactions between Minnesota law enforcement. Too many Black people have been killed as a result of unnecessary traffic stops that escalate. An air freshener should not be a death sentence. Further civilian oversight will remind law enforcement that we are all part of the same community. I truly believe that if bills like this one have existed before April 11th, that my son would be alive today. Well, nothing can bring my son Dante back. I would like to see justice served. As helpless as I feel, I want to ensure that what happened to Dante never happens again. No parent should have to endure this kind of pain. You have the power today to spare so many people of the grief that we're carrying, that we're going to carry for the rest of our lives. I'm asking you to do the right thing and vote in favor of these bills in Dante's name. Thank you.
Thank you, Ms. Wright. Thank you for being with us today. I cannot imagine the pain. As a father and a grandfather myself, I just cannot fathom it. And so we're honored that you took the time to be here with us. And please know that our love and wish for peace and for accountability and justice follows you. Thank you for working to make sure that we do better and honor people's lives in the state of Minnesota in a better way. Thank you so much. Mrs. Storm, I'm going to turn to you just sort of as perhaps a de facto coordinator to see who might you might recommend next on that list to speak. And you're muted, sir.
Oh, yes, I'm here. I'm Brandon Williams, nephew of George Floyd. I have a statement prepared on behalf of the family.
Welcome, sir.
Thank you. This past year has been one of inconceivable pain for my family. My uncle was wrongly and unnecessarily taken from us, and nothing can ever fill that hole in our hearts. While grieving in the national spotlight has not been easy, we are deeply gratified by the outpouring of love from people around the country and the world. Now the action is on you guys to pass these laws and bills to ensure that just as his life, sorry about that, just as his life had meaning, his death will also have meaning. And we will be the catalyst for change. The name George Floyd has become a household word over the past year. He's become the symbol of what's broken in a relationship between police and communities of color. When we watched him choke out the words, "I can't breathe," he was speaking for people of color everywhere. These bills will hold law enforcement accountable for misconduct, improve transparency through data collection, and reform police training and policies. On behalf of our entire family, our deepest hope is that this law will prevent many other families from having to endure the heartbreak that we live with every day. That was our statement, but I have a few things on my heart that I feel is necessary to say. For one, I would just like to say that these laws should get passed because it will definitely be a beginning to stop families from going through what we're going through and to feel this pain. As we were out there in Minneapolis throughout the duration of the trial, we had the chance to meet Dante Wright's family, of course. And as you can see, Miss Katie's hurting. Dante had a child. George Floyd had a child. Those children are scarred. Nothing can heal that, not therapy. But what we can do is change it to make sure that more children aren't going through these similar situations and losing fathers and mothers when they don't have to. A lot of these encounters with police are minor infractions that can be de-escalated quickly, and somehow they end up in Black men and women being killed that's unarmed. I also feel that whenever it's a mental health call, that police shouldn't come alone. I think they should have someone that deals with that specifically to de-escalate situations, because a lot of times that we've seen over just even the past few months, people are getting killed and they have mental health crisis when they can be arrested or de-escalated, like oftentimes we see when it's not people of color. You know, we've seen situations where certain individuals have taken several lives and they get arrested and detained, handcuffed without a scratch on them. As a Black man, we shouldn't fear encounters with police. We shouldn't have to have talks with our kids to tell them how to encounter police when, they're getting pulled over for a simple traffic stop. I think that these laws will help everybody. It can be the change that we need. It can be the change and the beginning of police encounters that don't end deadly. I feel that police officers need to be held accountable. We need some transparency, and we need actions. All of the meetings are cool, but we need actions. We need to see results. We need to see things happening and not being talked about, and we need it done with urgency. George Floyd was like my father. He raised me. I talk to him every day. Even after the guilty verdict, I find myself crying some days, when I just take a look at the TV or open up social media, because he's everywhere. That pain will never go away. But what we can do is prevent another child, another kid, another father from being taken. And that's what we need. Thank you.
Thank you. Thank you so much, Mr. Williams. Your family, the Wright family, did not deserve this outcome. I think we all here can say that confidently of one another's beliefs and hopes. And I want to thank you for your vision and the Wright family's vision for a better way for all our people here. Much love, support, and gratitude to you and to your family.
Mr. Chairman?
So much.
Senator Limmer.
I know you're on a very tight schedule, but I wanted to make a comment.
Please.
The families who have lost loved ones.
Yes, please.
Those of us who are in state government certainly have feelings for our constituents and families. And we know that you have suffered loss. We can't avoid that. And I wanted to offer my sincerest sympathies to the families that are giving testimony today. I believe that those are the two representatives of families that you'll be having today, Mr. Chairman. And I just wanted to make that effort that the sympathies that we have for the families that both you and I, Mr. Chairman, share, and that we're it's very unfortunate circumstances, and we're trying to understand everything, not only in the background, but as well as the incidents, and then going forward. And we just wanted the families to know sincerely that we are holding you in our thoughts and our prayers.
Thank you, Senator Limmer.
Thank you.
Yes, Mr. Starnes?
I just wanted to thank everyone for your time and just impress upon everyone, you know, a group of us, many of us here on this call found ourselves in the epicenter of a very important historical moment. And we just, really urge everyone to keep that in mind. And, as you all move forward to work together and hopefully pass bills that can have the reform and change we're all hoping for. So thank you.
Thank you, sir. And I don't want to neglect Mr. Marcelin, who did join us. And I don't know if you want to say a few quick words, Mr. Marcelin.
No, I think Attorney Storms covered it all. Thank you all.
Very well. Thank you, sir, for being here with us today. Members, we are actually just about caught up with our time. And so what I want to do then is to move into the distinct legislative provisions that these good people referenced broadly now, and just do much more quick focus on each one of those. And so I'm going to begin with calling forward Julia Decker, Policy Director of American Civil Liberties Union, who will speak to the provision in the offer of cite and release warrant proceedings. This is being carried by Representative Long in House File 2539. This would create an opportunity for non-arrests enforcement, but non-arrest enforcement of certain warrants to stop pretextual stops for minor issues. The purpose of this is to minimize deadly force interactions that we just heard referenced by Mr. Williams. So with that, Ms. Decker, if you can come forward. Oh, I'm sorry, we have something just, I'm just being notified by my staff that I did jump over someone. Ms. Decker, if you can hold off for a second, is that okay? Very well. My understanding is that Mr. Ben Crump has entered the room. And so Mr. Crump, if you can come forward, identify yourself for the record, give us your testimony. Thank you for joining us here today.
Thank you so much, Representative. I also have Brandon Williams, the nephew of George Floyd, and Miss Katie Wright, the mother of Dante Wright, present. And I don't know if they've been able to give their testimony.
They have, sir, yes. Thank you.
Thank you. Well, the only thing I would add is that it is just vital that we don't lose this moment to try to have meaningful police reform that can hopefully prevent some of these completely unnecessary, unjustifiable killings of people who did not deserve to be taken from this earth at this time. And we believe that it can be done. We just have to have the desire to have better policing for everybody in every community. I think about the common sense things that we should engage in. I think about George Floyd and the tragedy, the fact that the officer has so many prior allegations of excessive force, but because you have these arbitration clauses, the chief and the people who identify that this is a problem, at some point he's going to kill somebody, their hands was tied. So we need to look at what they're trying to do in the city of Minneapolis to say, give the police chief and the management authority to try to do the right thing to make sure that Katie's son can be treated like children living in different zip codes who get treated totally different when they're stopped by the police. That's all we seek is equal opportunities for our children to make it home safely too. No different than any other parent wants. And I trust and believe that the leadership wants to, just like Katie, just like George Floyd family, want to prevent anything like this from ever happening again. Ever. Minneapolis is ground zero for this next phase of civil rights. The whole world is watching the state of Minnesota. And I pray that we can all follow your example and responsible leadership to give all our children equal opportunity at life and liberty in the pursuit of happiness. I thank you so very kindly for your time.
Thank you, sir. Thank you for your lifelong commitment to justice and equal opportunity, especially for those who are often left behind in our society, and our society that often, very often falls along racial and income lines, especially along racial lines. So appreciative to you for your work. I join you in your desire. I think that's true of many, many legislators here. We believe it can be done. We simply have to commit to one another to continue to structure the ways in which we can do that through statutory law. But thank you, sir, for your work and for your words of wisdom. Members, I'll open this up for any quick conversations or discussion at this point.
I would like to say, as a family, it was said that it was only 2 families on the call, when in fact, yes, there are other families on the call as well. Yes. And because we are not the cases that everyone, has heard about, that have been swept under the rug, it doesn't mean that our loved ones, that it should be said that it's only 2 families. It's other families on this call as well.
Absolutely, Tashira. We will continue having the conversation. We're looking forward to hearing from you and from some of the other family members as well. You're absolutely right. Chair Beckerfin.
Thank you.
Thank you.
Yeah, I just wanted to thank the testifiers and the family. I know that there's an emotional toll with testifying in a place like this and being so vulnerable in front of a lot of people and sharing your story. And I know that it's it's hard, and especially when you're grieving. And so I just want to acknowledge that and thank you for your time, because it is powerful. And, you know, I can tell you that I am listening, and I know that many of my colleagues are as well. And I just want to acknowledge that and thank you all for being here today.
Well said. Thank you, Chair Bakerfield. Anyone else? All right, very well. We'll continue with the testimonies, and we will hear from Tashira and some other families as well. You know, it's this chair's belief and this legislator's belief that our work is should always be centered on the very real experiences of our citizens and our people in our state. And I think we get to better laws when we listen to one another, and we listen to the families and individuals in our state, particularly those who have been harmed either purposely or unpurposely, you know, through our systems. With that, I'm going to ask Ms. Decker if she can come forward again. And she's here to speak on the provision found in House File 2539. And I'll let you, Julia, quickly describe that and then tell us the why and your advice on this. Welcome.
Thank you, Chair Mariani and Chair Limmer and members. Julia Decker, I'm the policy director for the ACLU of Minnesota. And as the chair indicated, I'm here to speak specifically to provisions from HF 2539, which would limit custodial arrests in cases of warrants issued for a failure to appear for a court date on certain non-felony offenses. The ACLU of Minnesota supports the principal aim of this provision, which is to reduce unnecessary contact between law enforcement and members of the community. People may fail to appear for a scheduled court date for a variety of reasons. Access to transportation or transit, childcare, time off from a job, lack of a stable address are all reasons why a person may not be able to appear for a court date, and indeed may not have even been aware that they had a court date in the first place. In addition, as we testified previously, we would continue to urge the committee to consider that the severity of a charge does not change any of these access issues, and further, that a charge is not a conviction. Now, there are many ways that Minnesota's public safety and legal systems threaten civil liberties, disproportionately harm low-income and BIPOC Minnesotans, and criminalize poverty. Changing Minnesota law to limit custodial arrests for failure to appear on certain charges takes a good, principled step towards addressing one of these issues. The critical question now is not just looking back and asking what changes in law could have saved Daunte Wright's, George Floyd's life, but looking forward and asking the system's questions, like whether a custodial arrest for a pending charge or failure to appear should ever be the default response by armed law enforcement. So we at the ACLU of Minnesota are committed to working with this committee and the legislature to build on this and other proposals in order to enact change that is transformative not only in name, but also in substance. Thank you, Mr. Chair.
Thank you, Ms. Decker. And if you can stick around for a few minutes to see if there are any questions, I'd appreciate it. Next, we have Dr. Maria Ponomarenko, Associate Professor of Law at the University of Law School, who will speak on limiting certain traffic stops for equipment violations. This will also be part of the offer today, and it's filed in Representative Frazier's House File 2529. Welcome, Dr. Ponomarenko. If you can state your name for the record and give us your testimony, we'd appreciate it.
Thank you, Chair Mariani and Chair Limmer and the conference committee members. And thank you so much for inviting me to speak with you today. My name is Maria Ponomarenko, and I'm a law professor at the University of Minnesota. And I'm also the co-founder and counsel of the Policing Project at NYU School of Law. At the Policing Project, we worked closely with police departments and community members in more than a dozen jurisdictions, including New York, Chicago, Los Angeles, Tucson, and Nashville, to help make policing more equitable, effective, and just. I'm here to talk today specifically about the bill to prohibit officers from stopping drivers for certain low-level infractions, such as hanging objects from a rear-view mirror or driving with expired tags. As others have said, these sorts of stops often are used as pretext to look for evidence of more serious crime. Now, you've heard already both today and prior about the many harms of pretext stops, particularly in our communities of color. Today, I want to address the notion that these harms are something that we need to accept in order to give police the tools they need to keep us safe. And what I'd like to suggest is that is very far from the case. So in 2017, the Nashville Mayor's Office and the Nashville Police Department invited the Policing Project to evaluate that department's use of pretext stops as a crime-fighting tool. Like many agencies, the department had instructed its officers to go into higher crime neighborhoods and to look for people to stop. Sometimes the stops were based on vague tips or hunches that would not have amounted to reasonable suspicion. Other times, officers would simply stop the first car they saw. The vast majority of these stops were low-level stops for a broken taillight, broken plate light, hanging tags. Everyone in the department, from the command staff on down, emphasized to us the importance of pretext stops, both as a way to establish presence and to look for evidence of more serious crime. The data, however, did not back up these assertions. So working with researchers at the Stanford Computational Policy Lab, we looked both at hit rates for the stops, which is to say the number of stops that actually led to arrests for more serious crime. And we also evaluated the impact of stops on crime rates in the neighborhoods in which they were used. What we found is that only a tiny fraction of stops, less than 1%, resulted in a gun charge, the discovery of an outstanding warrant, or an arrest for a more serious crime like robbery or burglary. The vast majority of people stopped turned out to not be guilty of anything other than the low-level offense that had been used to justify the stop. Now, importantly, we also found that these sorts of stops had no effect on crime rates in communities. Now, crime rates naturally varied over time in different parts of the city, but they did so completely independently of whether officers were flooding a particular neighborhood with large numbers of stops. Indeed, there was some evidence to suggest that these stops were counterproductive because they alienated the very residents that the police department needed to cooperate with the police in order to meaningfully address violent crime in those neighborhoods. Now, to the department's credit, they very quickly realized that there were in fact better ways that they could spend their time. So in the 2 years after our study, the department cut stops by more than 80%. The department now emphasizes that traffic enforcement should focus primarily on traffic safety, and it relies on more targeted strategies, often working in collaboration with residents in order to address violent crime. And in this regard, Nashville's story is not unique. Fayetteville, North Carolina, also similarly found that by separating traffic enforcement from criminal enforcement, they were actually more effective both at reducing traffic accidents and at investigating more serious crime. And I'd be happy to point to other examples as well. Now, I just want to close with 2 additional points. So first, I just want to emphasize that other states have already taken steps to limit pretext stops in various ways. Virginia recently passed a bill that looks a lot like what is proposed here. Other states have also tried to reduce the incentive for officers to make pretext stops, for example, by prohibiting them from asking for consent to search in the course of a stop. The other point that I also just want to underscore is that officers already have the authority to pull someone over if they reasonably suspect them of criminal wrongdoing. And as the lawyers in this room well know, this reasonable suspicion standard is not a particularly demanding one for officers to meet. All this bill does is make clear that when somebody is guilty of little more than a minor vehicle infraction, an officer's vague hunch that they may be up to something more should not be sufficient to justify making a stop. Thank you so much.
Thank you, Professor. So members, I propose we'll stop for a few minutes to see if there are any questions or thoughts on these first 2 bills that Ms. Decker and Dr. Ponomarenko just spoke on. Chair Beckerfield.
Thank you, Mr. Chair. And I'm wondering if Ms. Ponomarenko can speak a little bit more to, yes, we know that it makes it safer for the person being pulled over, but if you could elaborate a little bit more on, the other ways it makes our community safer as well as safer for officers.
Dr. Paramarico.
Of course. So, traffic stops are dangerous for everybody involved. An officer has to approach a car without knowing who's in the car, whether that person may be armed. As we've seen, that often puts officers on edge, and that increases the likelihood that force is going to be used, including in circumstances where it turns out to not be reasonable. And so both from the perspective of the people stopped, but also officers themselves, to the extent we can reduce these kind of high stress situations, the more likely we are to avoid harm to residents, avoid harm to officers, and avoid the tragedy of having, an officer who now has ended up, shooting somebody or otherwise causing harm.
Chair Limmer, I thought I saw your hand up at one moment. I'm not sure. You did share earlier that you were struggling with that hands up, and you and I share that in common. So I just want to make sure.
Yeah, thank you, Mr. Chair, for recognizing. I don't know what happened. The hand just blinked off on the screen. So I have to get a flasher or something to put it up and down. I had a background question. Perhaps Ms. Decker could give me some information, just some background information in Minnesota. When one gets a request to show up at a court, she had brought up the issue of failure to appear and a variety of issues that could affect a failure to appear in a courtroom. Does anyone know how long a time period from the issuance of I suppose it's a summons to get to court versus the date of the court appearance? What's the gap in time? Are we giving a short period of time for someone to show before court, to get a proper opportunity to arrange their schedule so that they're not, can they make arrangements with their employment? I think it's also an issue with people that are not in poverty. Also, it may be very hard to show up if it was a short period of time. But does anyone know the time gap between the issuance of a summons and the date of appearance? Is it a month? Is it longer than that? Does anyone know?
And Chair Limmer, perhaps our legal counsel might be able to help as well, but I'll start with Ms. Decker to see if she wants me to refer to our counsel.
Mr. Chair, I think that would be appropriate.
Okay, very well. Let me put our legal counsel on the spot. And if not, we've got, I think, plenty of prosecutors here in both on the committee and in the audience. But perhaps Mr. Johnson and Mr. Debo might have some thoughts on this.
Mr. Chair, this is Ben Johnson with House Research.
Mr. Johnson.
Mr. Chair, Senator Limmer, members, I think the answer you're going to get is that it's not consistent, that it's going to vary from county to county. Different counties have different scheduling issues. In the metropolitan area, it might take a little longer in some cases. However, they also have more judges. So I don't think there's a uniform answer that can be given to that question.
Mr. Chairman and Mr. Johnson, is there any knowledge of a particularly short period of time of notice that we have heard about?
Mr. Johnson, and again, we also have some prosecutors on our committee who might have some other insight, but Mr. Johnson.
Mr. Chair, Senator Limmer, I don't think I can give you a good answer to that question. Nothing has ever been brought to my attention. I've never seen a bill on that particular subject.
I haven't heard that until today. I know there's plenty of obstacles in the way of everyone's schedule, but I was just wondering about proper notice.
Chair Becker-Finn, to this point.
Thanks, Mr. Chair. And I was going to say partially what Mr. Johnson said, that it really depends. The notices are sent out by the court. And so it really depends on, also what kind of case it is and how long it's going to take. But I mean, I certainly know in my work working with victims at the Domestic Abuse Service Center that, we would sometimes get a call saying, oh my God, I just got this notice that my thing is scheduled and it's tomorrow and that isn't enough time, you know? So I think especially now too, that folks are seeing longer delays in the mail as well. And we also don't always have a good way to verify that we're sending it to the right address. You don't know until it kind of goes through the system and kicks back to you that we didn't have a good address on file. So I think those are all factors that can play into that.
But certainly, it's my understanding that in Duarte Wright's case, there was a wrong address issue involved, and so questionable whether the young man was even aware, you know, of that summons. Very well. Others? All right. Well, thank you. Thank you, Chair Limmer. With that, we'll move on to the next group of bills in the offer. The next one is modification to post-board police misconduct database. I'm going to ask Representative Frazier to speak to this issue. Oh, no, I'm sorry. It's Representative Frazier's bill. I'm going to ask Chair Kelly McCarthy, Chief McCarthy from the Post Board to speak to this issue. Welcome, Chief.
Thank you, Chair Mariani and Chair Limmer and members of the committee. My name is Kelly McCarthy, and I'm the chair of the Minnesota Peace Officers Standards and Training Board, as well as the chief of the Mendota Heights Police Department. House File 1374 allows for the appropriate data to be shared between individual agencies and the Post Board. The data is necessary for the Post Board to fulfill its legislative mandate regarding our alleged misconduct database. Any data shared between the agency and the Post Board will retain its original classification. Private data would still remain private. This information is necessary for us to shape training and really analyze the data in an appropriate and effective way.
Thank you, Chair McCarthy. And Chair Limmer, you and I worked on that legislation this summer, and the proposal here really is to make sure that the legislation that we worked on can be most effective. And we didn't have all that information at the time. We do now, particularly as we're looking at, I believe the Post Board is looking at best practices across the nation, has gotten expert advice, consulting advice in the construction of that vitally important early warning system. All right, thank you, Chair McCarthy. Next, we have the law enforcement model policy on response to public assemblies. I'm carrying that bill, and Chief McCarthy, you're also going to speak on this one as well.
Yes, you're stuck with me, Chair. Thank you. House File 445 is asking that you legislate a model policy regarding First Amendment assemblies. This policy will benefit both the community and law enforcement. A policy that's made in the light of day with all stakeholders present will help direct officer training and response and behavior, and it will help shape community expectations. As a police chief, it will also aid in the helping local municipalities maybe resist the urge to create knee-jerk tactical decisions in an emergency, and will respect the voices of all stakeholders. And this gives us an opportunity to make sure that we are acting in the best interests of both our law enforcement and our community at large.
And Chief McCarthy, one of the things that I often hear with model policies, and not just this, but others, and the Post, has worked on some of these, and there are some new directives, possible directives and legislative proposals to do more. I know that a few years ago, the Post worked on investigations of sexual crimes, creating a model policy for investigations for our law enforcement units across the state that was, I believe, very well received across the state. But my question is that one of the things that I often hear is the issue raised of Well, you know, our community is very distinct from your community. I'm way up in the northwestern corner of Minnesota, and you're way down in the southeastern corner of Minnesota. And, you know, we like to think of policies that really match, you know, the culture, the times, the conditions, et cetera, you know, of our community. And we don't think it's wise to, quote unquote, be told what our policy should be. I think that requires a little bit of unpacking in terms of what a model policy is. But what's a good way to, what's the real on-the-ground way in which the Pulse Board has responded to and honors, if you will, you know, that very important local decision making.
Thank you, Chair Mariani, Chair Limmer. It is very important that agencies reflect the community that they serve, and both in their expectations and in the actual very practical way in which their law enforcement agencies act. So when we say model policy, it is a model, it is best practice. The policies of the individual agencies just have to be substantially similar to that model policy. It is not an exact, it is not a word for word. You can change those areas of the policy that simply do not apply perhaps to your agency. So for instance, if we have some information regarding best practices regarding drone usage, well, the Mendota Heights Police Department doesn't have a drone. So we wouldn't include that. We would be able to put in the things that really reflect the character of our city. And so when the Post Board does compliance checks to ensure that agencies have model policies, they're just making sure that they are in the right vein and they reflect the best practices that are outlined in that model policy. So it's as much of a resource as it is anything.
Thank you, Chief. I appreciate it. Anyone else? Okay. Very well.
Chair Mariani?
Oh, yes, Chair Limmer.
I got my hand up this time.
You know,
a little late, but I did have a quick question.
Please.
Oftentimes, when one is looking at model policy, I believe that the issue has to be written broadly enough to accomplish uniformity under the law. And yet, I'm not quite sure how you specify the difference from one community to another. Oftentimes, I hear our rural members concerned when urban legislators write law that affect their areas way out in, you know, the outer reaches of Minnesota. So I think it has to be written general enough to apply in both locations. Otherwise, you won't have equal treatment under the law, which I think is one of those constitutional things that we have to satisfy. One of the concerns I have, and it's just open, I'm just throwing it out just for a discussion, where does one draw the line between freedom of speech and public disturbance? And I don't know if law enforcement really knows the difference. And perhaps it's, is it the volume of the protest? Is it something that's added to the verbal exchange? Is it the quality of the words? Is it profane? Is it too loud that violates a noise ordinance? All sorts of things. So it's just not limited to the words. It's also the actions. And I think if there's any area that one could work on is drawing that line between freedom of speech and you know, the public disturbance. But I'll just leave it there. I'm not seeking an answer, and I'm not wanting to put Chief McCarthy under the pressure to answer that question. But I think a number of police departments since the death of George Floyd has been struggling with it as protesters have come into areas, not only in Minneapolis and St. Paul, but in suburbs as well.
Chair, if I may, Yes. Chair Limmer, I'd love to have that discussion with you. I don't know that this is the time or the place, but I do think it's important that we remember there is illegal activity and legal activity. And the majority of the activity that goes along for the First Amendment policy is legal. And when it crosses into illegal activity, then we take a different action. But like I said, I would love to have that conversation with you, and we can bring in Theophrastus and the idea of acts committed in anger versus acts committed in pain. And I'd be more than happy to discuss that with you.
Wonderful, thank you. I'd love to sit in on that conversation too. Very well, thank you, Chief. Next we have the prohibition of law enforcement affiliation with white supremacy groups. This is Representative Frazier's bill in the House and Senator Fatah's in the Senate. And to speak to this issue, we have Justin Terrell, the Executive Director of the Minnesota Justice Research Center, and also on the Minnesota Post Rules, or actually as chair of the Minnesota Post Rules Committee. Welcome, Mr. Terrell.
Thank you, Chair Mariani, Senator Limmer, Vice Chair Frazier, the author of the bill that I'm speaking to. I just want to say thank you for having us, and thank you for to the community members who showed up to speak earlier. I'm humbled by their presence and thankful that people continue to speak out and demand that we get this right in Minnesota. I'll keep my remarks short. Trust is low when it comes to police and community relations. It's at a 27-year low. We know that this is a problem. Officers can't do their job well when communities don't trust them, and the officers don't trust community. So we have to take actions to address that level of low trust. This standard, this white supremacy standard is pretty basic. Many professions have this standard. It only is reasonable that a profession such as law enforcement that has grown out of a history that is tied at every intersection of history that is intersected with the oppression of people of color. Law enforcement has been part of that story, unfortunately. Not to condemn anyone or any one profession, but the history is there. And so white supremacy then is, as an ideology, and the organizations that profess this ideology is a threat to law enforcement, and is a threat to our community, is a threat to our state, is a threat to our nation. And much has been said so, from Merrick Garland down to 3 different FBI reports and several tons of research, including our own, over the last 20 years. I come to you to speak in favor of this bill today because I believe it kind of speaks to the common denominator. If community and police and law enforcement can agree on the fact that we need to have a reckoning with white supremacy in law enforcement, then I believe we can start to build trust again. We have to deal with the very fabric or the very soil that this profession has grown out of, if we're ever going to be able to reconcile our communities. And a moment of that reconciliation happened during my first post-board meeting, when we voted unanimously to adopt this standard into the rulemaking process. And I have to say that we had unanimous votes from community members, unanimous vote from law enforcement. As someone who's sitting in the seat that was vacated recently by Philando Castile's uncle, Clarence Castile, I wanted to make sure that we did the work to set this ground, sort of this foundation of the work that we'll do together on the post board. And I was really encouraged by the amount of support that we got from law enforcement. And so if we can do it on the post board, if we can bring folks together from community and law enforcement to support this minimum standard that would prohibit licensed officers in the state of Minnesota from associating with white supremacist terrorist groups, who have been identified as the #1 threat, domestic terrorist threat in our country, then I expect that this body can get on the same page with community and law enforcement and pass this bill. And so I thank you for the time, Chair, and I will conclude my comments there.
Thank you, Mr. Terrell. I read with interest this weekend, I think it was an AP story on the white supremacist movement of the 1980s, which became an incredible threat that produced all sorts of crimes. It's the way that particular movement was bankrolling itself. And when national law enforcement got onto it, it had grown quite strong. And there were a lot of unfortunate tragedies with people being killed. One person targeted and assassinated a Jewish radio talk show host in Denver. But it was a powerful comparison of what some of the dynamics that the FBI has been tracking over the course of the last decade. I think it's indeed quite a serious issue. I'm glad that the Post has moved. I always think that it's important for legislators to move. The statutory law should be the first most powerful way in which we do things. We revert to rules, when we have to, and we've given bodies the authority to do that. But I think it's important for us to have a good, strong statement and actual law emanating from our legislature on this issue. And Mr. Terrell, you're also speaking on the next provision, so we'll do a McCarthy on you as well. And this is requiring our CLEOs, Chief Law Enforcement Officers, to submit duty to intercede reports to the Post Board. This was a bill that was introduced by Representative Lucero on our committee, and we heard it in our committee hearings. But Mr. Terrell, to this issue.
Yeah, this is a very important bill. So this is once again another basic standard that would require officers, regardless of rank, to report excessive force to the Post Board, so that the Post Board may be able to not just investigate, but also to collect real-time data on excessive force reported by officers. And I think that there's a lot to be said about this bill, but I think that the main point here is that we've witnessed so many excessive force incidents that have gone awry in our state. And if other officers knew that they had a requirement to step in and say, you know what, this has to stop. There are several people that still may be with us. And I'm thinking about the families on this call right now. And so I don't have much to say about this, except that it's a very, minimum standard bill that I know officers in the field who have told me stories, not to describe anyone specifically, but where they have had to intercede and didn't know that they would have the support of leadership if they were to try to make a report. And so this bill clears that up. It says that we will support you, we will investigate, we will collect the data, and we'll make sure that law enforcement officers know that if they stand up, that they're not standing up alone. The last example I'll give here is just recently it was reported, in the case of George Floyd, that after he was murdered, MPD put out a statement calling it a medical emergency. And how would that statement have changed had the officers on the scene had reported that as excessive force? These are the things that I just think just make a whole lot of sense. We have to stop being reactive and start getting on the front end and make sure officers know that they're set up in a way to show up and be successful, as opposed to being set up in a way where they end up in tragedy and they don't have any options to respond. And so I encourage this body to support this bill. I'm thankful that Representative Lucero brought it forward. He and I both have an appreciation for data, and I believe that this is a bill that would help us collect more real-time data at the Post Board as well, which is, I can't explain how important it is that we expand our ability to collect data at the Post Board. So thank you.
Thank you, Mr. Terrell. We have a question from Representative Frazier.
Thank you, Mr. Chair. Thank you, Mr. Terrell, and then also thank you, Chair McCarthy. I've got a couple of questions. One, I just want to make a note that this bill that Mr. Terrell just spoke about, the reporting of the excessive force, that is a bill that was authored by one of our GOP colleagues. I just wanted to make a note of that in terms of the agreement that we have around that, something that needs to happen. That's a bipartisan issue. And to Chair McCarthy, can you talk a little bit more about the database, the early warning system that we're trying to prepare here, and kind of how that works?
Chair McCarthy.
I wanted to make sure that I had my stuff, and good thing I didn't take my tie off. So part of the reforms from last session asked the post board to collect more robust data as in regards to alleged officer misconduct. Historically, the post board has collected data, but it's been aggregate data. So it's aggregate data on alleged complaints in specific areas. So what the legislature has directed and what we are working on is to take that data and really put a finer point on it, which will allow us to then direct training to those areas in which officers are receiving complaints or where there's issues. Too often, we kind of go whichever way the wind blows. And unfortunately, the reaction to tragic incidents is important, but if we really want to fix the underlying issues, we have to be able to back up and address the issues, the systemic issues that are causing these things to happen. And so this database is a step in the right direction to allow us to do that.
Representative Frazier.
Thank you, Chair McCarthy. Just before I forget, I should have noted to give credit to my GOP colleague, that was Representative Lucero who authored the bill around the reporting of the excessive force situations. Chair McCarthy, one more question. Could you explain how the bill that would modify the data for this early warning system would be helpful so that you all can achieve the goal that the legislator actually intended for you to achieve?
Chair McCarthy.
Thank you, Chair Mariani. Yes, Representative Frazier. I believe this was actually a request from the post board, from our executive director, and so he can speak with much more detail than I can. But one of the odd things in the data practice statute is that certain individual identifiers are private, and so we would not be able to link any information back to a certain individual. This would still make that data private, but allow it to be shared with the post board. So you'd have Officer A in an agency, and we'd be able to see that they haven't had any complaints, or Officer B, and we'd be able to see that they've had 14 sustained complaints in one area. So we could use it in conjunction with that reporting agency to tailor training specific to departments or officers and really be responsive to local agencies and local communities and ensure that they are getting the policing in the way that they want it and deserve it.
Representative Frazier.
Thank you, Chair McCarthy. So what I'm hearing you saying, and just want to be clear, is, I mean, this really would help you to be an early warning kind of intervention system, which could prevent possibly lethal use of force and deaths.
Chair McCarthy.
Thank you, Chair Mariani. Yes, Representative Frazier, it is one component of a early warning system, but it is absolutely a step in the right direction.
Very well, Representative Frazier.
Thank you, Mr. Chair. Thank you, Chair McCarthy.
All right, very well, thank you. I don't see any others, so I will then move on. Next, we have Michelle Gross, who will speak to from the Twin Cities Coalition for Justice. For Jamar, she'll speak to local units of governments authorized to establish law enforcement citizen oversight councils. Ms. Gross, welcome to the committee.
Chair Mariani, Chair Limmer, and members, thank you for having me today. My name is Michelle Gross, and I'm actually with Communities United Against Police Brutality. The speaker from Twin Cities Coalition unfortunately had an emergency, and so I'm replacing her for today.
Very well.
I'm here basically to talk about the civilian oversight provision in the Omnibus, which is Article 10, 22, and 23. And basically, this provision simply repeals Minnesota Statute 626.89 Subdivision 17, allowing communities that wish to do so to create civilian oversight councils and possibly grant them with certain powers. Such oversight bodies hold the promise of improving trust between the community and law enforcement because communities become invested in creating the standards for which they wish to be policed. This bill is permissive. Communities may create these bodies, but they're not required to. Some communities may see no need to create these bodies. However, in a number of communities, and I happen to live in Minneapolis, in a number of communities in which policing has been more problematic, community members are eager to set expectations for the policing to which they are subjected. This portion of the Omnibus bill allows them to do just that while still preserving the rights of law enforcement officers to the grievance procedures outlined in their collective bargaining agreements. In 2012, civilian oversight bodies were stripped of their ability to operate effectively as a check and balance against police misconduct. Had these bodies been given adequate power to truly serve an oversight function, it is unlikely that former Minneapolis police officer Derek Chauvin, with 26 civilian complaints and 4 prior deadly force incidents, would have remained employed by the Minneapolis Police Department long enough to have had his deadly encounter with Mr. Floyd. I want to just mention one other thing, which isn't in my prepared notes, but I want to just talk about it for a second because it came up a little earlier. And that is the idea, which I've been hearing lately, that we should just wait and allow the efforts that were made last summer, the provisions that were passed last summer, to go into effect and just wait and see what happens out of those. Bluntly, those provisions were not enough, not strong enough, and not enough to solve the problems. I do not think that we have the time to continue to wait to see if those watered down small measures will do anything enough to prevent another incident like George Floyd or Dante Wright or the many others that we've had. I don't think it's enough. I strongly argue against the idea that we should just wait and see if these tiny incremental measures would do enough to prevent these issues. I don't believe they will. And I urge this body not to wait any longer, but to adopt the very common sense measures that we've put forward. You know, we're not asking for extremes here. We're asking for common sense measures that would make police and the community more able to work together and to achieve our common goals. And so that's part of my ask for today as well. And so I thank you for your time.
Thank you, Ms. Gross. And we'll get back to you in a minute because you're going to speak on another issue, I believe. But before then, we're going to turn to Ms. Tashira Garraway, who we heard briefly from earlier. And Tashira, my understanding is that there's been some tragic news in your family with a suicide of the brother of Justin, I believe, who was killed, several years ago. And so my condolences to you. It's so painful. And so for you to be here, I just really want to honor that. And it must be a bitter sweetness because I believe it's also your birthday today. So really appreciate you being with us here today, Tashira. You're here to speak on the statutes of limitations for eliminating statutes of limitations for peace officers on wrongful death, civil actions.
Yes, I am. I am going to try my best not to cry in this call, but I just want to say that when they murder our loved ones, it doesn't just stop at the fact that they murder our loved ones. It creates a ripple effect throughout an entire family. And this brother who did this today, or he would cry about his brother being murdered by the police. It's also been a sister that died after Justin. She would cry about the police killing her brother. So the mother has actually 3 kids gone now. It is really hard to handle at this point, but I just want to talk about the statute of limitation because one of the things that happened was intimidation after Justin was murdered. I was followed, Justin's mother was followed. They would sit outside of our homes after Justin was brutally beat to death by the St. Paul police and thrown inside of a trash dumpster, August 19, 2009. I have significant evidence to prove that Justin was murdered by the St. Paul police. And the statute of limitation, the reason that our families, this is so important to us, is because it doesn't just give justice right out the gate, but what it does is it creates a way for the families to bring forth their cases without a time limit. Because because of the intimidation, families are afraid to come forward with their cases. This is true and this is real, what's happening. In addition to that, families are mourning. So we were in the most horrific, devastated place that we could ever be in when we lost Justin. Walking in and seeing his skull cracked in half and dog bites on his body after being pulled over by police. So we didn't understand all of the logistics of how it worked with the lawsuit because we were hurting. We were mourning like any normal family. While that was going on, we were illegally having evidence withheld from us by the police department. And the case was being held open, and there supposedly was an investigation going on. So therefore, while all of this is going on, the mourning for our family, the open investigation, the non-cooperation from the police department, as well as the intimidation, we looked up and that 3-year limit was up. If someone is murdered unjustly and the family can prove that their loved one was hurt or harmed unjustly, there should be no time limit on when someone can fight for justice for their loved one. And I'm going to say this and be quiet because I know we have a time limit. There has been over 470 murders at the hands of law enforcement in the last 20 years. These are not isolated issues. There is a clear indication that it is a problem here in Minnesota. We lost our loved ones here in this state. And for every high-profile case, for Philando Castile, Jamar Clark, George Floyd, now Dante Wright, it is clear that it is a problem here in Minnesota. The biggest high-profile cases in history have come from this state, and yet we are failing. We are falling behind other states that are passing meaningful legislation. We need you guys to work together. We need the Senate to give hearings to these bills. We need you guys to do that for our families and most of all for human beings. I am raising a 14-year-old son without a father, thanks to the St. Paul Police Department. And all I'm asking is that everyone come together, talk to our families, talk to the impacted people. We don't hate the police. We don't. I have police that are my friends. I just had a police officer call my phone to tell me happy birthday today. So I don't hate police, but I want people to do the right thing and be held accountable if they don't. And removing the statute of limitation for wrongful death will give that accountability and help the rest of the hurting families that are out here. Thank you.
Thank you, Ms. Garraway. And the bill does speak to being able to pursue a civic, rather a civil action. And so what I want to do is just very quickly turn to our House research, just to do a very brief description of what that bill does. This bill is being carried by Representative Vang in the House and Senator Pappas in the Senate. So I believe that might be Mr. Johnson.
That's correct, Mr. Chair. Ben Johnson from House Research. Mr. Chair, should I proceed?
Yes, please, sir.
Mr. Chair, the provisions that were being discussed up here in Article 7 of the House Omnibus Bill, they're Sections 8 and Sections 9. There are two similar sections in the bill. Both of them deal with the statute of limitations, again, for civil actions, not for criminal actions. Section 8 deals with the limitations period for sexual assaults, and it says that any action for damages based on sexual abuse may be commenced at any time in the case of alleged sexual abuse by a peace officer. Section 9 deals with death actions, what are often called wrongful death cases. That has a similar provision, and it says that an action to recover damages for a death caused by a peace officer may be commenced at any time after the death of the decedent. Mr. Chair, both of the provisions have effective dates that would effectively say that it applies to any cases where the statutes of limitations have not expired at this time. And it also sets a 5-year window for cases where the statute has previously expired. It effectively reopens that statute of limitations for a 5-year period. Mr. Chair, that's the overview. If you have any additional questions, I'm happy to answer them.
Mr. Johnson, I'm just wondering if, because I know that, it's very typical to have a criminal investigation, undertaken when there's a deadly force incident, and the police have to conduct that, they're required to do that. It seems to me that part of the issue, well, let me just ask a technical question, which is, what the period of time in which a criminal investigation, time period, happened, would that have an effect on civil litigation? Can you move forward with civil litigation prior to the end of a criminal investigation?
Mr. Chair, in response to that question, there's sort of a two-part answer to that. Part of the question is, can you commence or begin a lawsuit? And the other is, does it proceed? The answer to the first question is that yes, you can file and commence a civil lawsuit regardless of the status of a criminal case. The second question is usually assessed on a case-by-case basis by an individual judge or court, deciding whether or not to stay proceedings pending the outcome of any sort of criminal case. Some cases they do stay them, but not in all cases.
Okay, very well. Thank you. Thank you to Cheryl for being with us here today. Next, I'm going to turn back to Ms. Gross, who will speak on the regulating the use of no-knock warrants. Ms. Gross, we heard, I don't know if you're here, but we heard earlier from Deputy Chief, I'm blanking on her name now. And, sharing that there's an alignment with what the Minneapolis Police Department is doing relative to what's being proposed here in state statute. But if you can speak to this issue, this is Representative Holland's House File 1762. Senator Fate is carrying it in Senate File 2139.
Thank you, Chair Mariani and Chair Limmer and members. I just want to speak, briefly to this Article 10.7, which is limiting no-knock warrants. It doesn't eliminate them, it limits them. And it limits the use of those warrants to serious crimes, and it implements safeguards to ensure that these warrants are only utilized whenever absolutely necessary and with proper guardrails to protect innocent people from harm. These safeguards could have prevented the terror experienced by the Bianca Matthias and her daughter on February 11th, 2021, when their Coon Rapids home was breached in a pre-dawn SWAT raid. A simple check would have shown that police had the wrong address. The man they were seeking had moved at least a year prior. Because he was on probation, his correct address was actually available through court records. I want to encourage members to read the CARE 11 article about this incident that was recently covered. And I don't want to go into a long diatribe about all of the different harms and wrongs, but we do have to remember that they exist. And long before the Matthias household was affected, we've known about these problems with no-knock warrants. Nationally, between 2010 and 2016, at least 94 civilians and 13 police officers have died as a result of no-knock warrants. The searches are often for narcotics, which means not violent crimes, but those killed during those searches are disproportionately persons of color and the poor. And we know that, for example, like I said, in 1989, Lloyd Smalley and Lillian Weiss, an elderly African-American couple, were killed in their home after the Minneapolis Police Department set their home on fire with a flash grenade while executing a no-knock raid on their home. Turns out that the information justifying that no-knock warrant was false, as no drugs, guns, or any other sign of criminal activity was found. There have been, again, several other incidents like this. We know of one in North Minneapolis in which a Hmong couple was in their home with their 6 children. Police came in and the mother was still awake. She bolted upstairs to her husband. He grabbed his gun out of the closet thinking that they were being robbed and shot down the steps, through the open doorway. And then a volley of bullets were unleashed on this family. And it turned out that the shooters were Minneapolis police officers. The home was rendered uninhabitable, but luckily not any members of the family were shot or injured. But of course, the taxpayers paid the bill for that as well. And the family remains terrorized to this day. So these are all harms that can come from sort of the lack of guardrails around these no-knock warrants. Minneapolis to this day continues to serve about 3 of these warrants a week. We don't know how many other warrants are served in the state because there is no good reporting mechanism for these things. So what this bill will do is basically create those guardrails, put some measures of safety into place for everyone's safety, but also include a provision for reporting on the use of these warrants that will allow us to know how such warrants are served across the state and under what circumstances and justifications. Regular reporting will allow us to monitor agency compliance with the restrictions mandated in the rest of the bill. And while some agencies rarely serve no-knock warrants, others do so quite frequently. It's important that we understand the use of these warrants and that we can have the ability to assess that information. So I thank you for your time.
Thank you, Ms. Gross. And if you can stick around a little bit in case there's some questions,
certainly,
I'd appreciate it. Next, we have Travis's Law, House File 1686, Hanson J, Senate File 1924, Jim Abler. And this legislation involves 911 calls. Well, I'm getting signaled that I think someone had a question. I'm sorry. Yeah, Senator Latz. I'm sorry, I didn't see your hand up. Senator, please.
Thank you, Mr. Chairman. I did have a question about the no-knock warrant bill, if I may.
Yes, please.
I've got the bill language in front of me, and it indicates, please correct me if I'm reading this wrong, but it indicates that it limits no-knock warrants only to the following offenses: murder in the first degree, hostage taking, kidnapping, terrorism, or human trafficking. So there are a lot of firearms related offenses that are not included in this list. There are a lot of the top level drug dealing offenses which are not included in this list. And all of which I would think would have ample information to suggest that the person that is being sought for arrest is armed and dangerous. So I'm trying to reconcile those situations.
Yes, indeed. Senator Latz, good catch and actually very appropriate observation. This language is amended. And so, obviously we're referring to the bills as they're introduced to share that. In fact, there have been bills introduced, particularly across, the aisle in both the House and the Senate. But let me ask Council if they can summarize for you and for us the new language on your pertinent question. I don't know if that's Mr. Johnson or Mr. Deeble.
I'm sorry, I was just looking to pull up the provision here in the.
Take your time, Mr. Deeble. No problem.
Yeah. Yep. So the Senator Latze and Mr. Chair and members, it is limited, and as it was amended in committee in the House side to restrict it, their use for the offenses of first degree, murder, hostage taking, kidnapping, terrorism, and human trafficking. It was think that ended up being more of a reporting requirement was the key issue that was retained for their use, to track their use as it moves forward.
Senator Latz.
Well, I guess there's a bit of ambiguity there in Mr. Diebel's answer. It ended up being more of a reporting requirement, or the list of offenses was amended to be expanded, or was the list of offenses and the prohibitions was deleted altogether and it's only a reporting requirement? And what language is reflected in the side-by-sides? I haven't pulled that up to compare it. What's in the House bill that's before us right now?
Yep. Mr. Diebel.
Mr. Chair and Senator Latz, the version, it's in the Article 10 policing, and it's under Section 7 on the House side. And it sets out the requirements for no-knock search warrants. And they must include the documentation that the court requires, an affidavit from the peace officer, and then it sets out a form to be used. And so I see that I might have been citing the summary from the bill as introduced, but the language that's in conference committee, subdivision 5, has a recording requirement that law enforcement agencies shall report the Commissioner of Public Safety regarding the use of no-knock search warrants. And it's intended to give policymakers an idea of how the scope of their use and the range by agency and frequency.
So, Mr. Chairman, are we talking Article 10, Section 7, and that's the totality of this provision?
Mr. Diebel.
Yes, that's correct, Senator Latz.
Okay, so it sets out some minimum documentation requirements, which is basically whatever the court requires and a sworn affidavit. I'm not quite sure that's any different than existing law. And it sets out some detailed information in a warrant application form, and then has reporting requirements. So with some data gathering. Okay, that is a much different proposal that's before the conference committee than I thought we were talking about. So thank you for the clarification.
No, very good question. So there are guardrail issues here as well as transparency issues. So in many ways, working within the realities, their initial posture was, let's get rid of them. We interacted with law enforcement, who pushed back on, well, you need to think about this, you need to think about that. There was definitely a desire to raise the bar, if you will. And so ergo language before us. But my apologies for the confusion that my referencing the initial House bill and Senate bill might have caused.
Mr. Chair.
Yes.
I'm sorry, I didn't mean to interrupt. Ken Backus from Senate Council here. I thought maybe I'd point out to Senator Latz and the members, there is a provision in the House language that says under no circumstances may a no-knock search warrant be issued when the only crime alleged is drug possession. So it does have an actual bar for those type of offenses. And then as Mr. Diebel mentioned, the rest of it is primarily reporting and things like that process.
Very well, thank you, Mr. Backus. So Representative Mueller.
May I ask a follow-up to that?
I'm sorry, I thought Representative Mueller had on this point, but yes, Senator Latz, and then we'll turn to Representative Mueller.
No, I'd like to hear what Representative Mueller has to say on this point.
Okay, very well.
Thanks, Mr. Chair. I lowered my hand because Mr. Backus said exactly what I was going to say.
Got it. All right, very well. Senator Latz.
Okay, so then, Mr. Chairman, that provision on line 120.22 and 0.23, drug possession, is that, I guess I'm a little unclear how broad that is, because there are possession crimes which sort of by virtue of the quantity in possession automatically become presumed sale crimes as well. So I guess we might wish to get some clarification on that if and when we get down to the point of that level of detail on these bills. So, I mean, if someone's got a trunk full of meth and they're not caught in the act of selling, but they're presumed to have enough that it's really a sale situation, you know, which is that? Is that a drug possession case or is that a drug sale case? So I think we probably need some clarification at some point on that. And maybe I'm getting too much into the detail for what you're trying to accomplish right now, Mr. Chairman, but I think at least in terms of what we are being presented in the broad brush, should be helpful if we were precise enough so we know what's being proposed. Appreciate it. Thank you.
Thank you, Senator Latz. Senator Chair Limmer.
Thank you, Mr. Chairman. A question I had, perhaps research folks could answer this question. Right now, I presume that a judge who is going to sign a warrant for a no-knock search establishes in his own mind, or does he follow certain parameters now? What is the current status of the parameters that would allow a no-knock search? Is anyone in our research staff that could answer that question?
I'll wait to see if there is.
Apparently, Mr. Chairman.
Yeah, Mr. Chair. Sorry, this is Jeff Diebel. I don't have any precise knowledge that probably would advance the argument or the discussion. I'd probably defer to the prosecutors on the committee or perhaps even some of the other criminal law practitioners that might deal with that on a more frequent basis.
Mr. Chairman, the reason I raise it is I'm trying to get a comparison between current practice and the practice that's being proposed. I would imagine there's a judge that has to sign off on the warrant. A no-knock is a little bit, it certainly is more intrusive than knocking at the door. There's times if drugs are involved, if the suspicion is a large quantity, I think Senator Latz is correct, there's a presumption that there are sales involved. If it's a smaller, and who knows how much is a large quantity, certain drugs are much more potent than others and you don't need to have that big volume, but oftentimes the no-knock provision is designed to prevent the destruction or the flushing of a certain drug down a drain. And so a door knock might cause that opportunity for someone. So I was just wondering what the current practice was as far as a judge in the legal system is concerned. I'm assuming that a judge now works under a certain parameter, and we would be changing that in this proposal.
And Senator Limmer, I believe the intent here is to give procedures so that folks don't make mistakes. Clearly, we've got mistakes that have happened, and in the past, those have had some pretty, tragic outcomes. In many ways, there's a real focus on, sticking to, a violence standard. So if you've got a gun in the house, probably makes a lot of sense. If you're gonna, you're involved in something illicit. But if that's not the case, then we really want to be able to tone down the introduction of a unannounced entry with weapons. I think Representative Frazier wants to speak to this issue. Representative Frazier.
Thank you, Mr. Chair. You were starting to lead into what I was going to say, and I just to what Senator Latz was speaking to. I think, yeah, you're right. I mean, these warrants will still be available. That just raises the bar and the standard for how a judge is going to sign off to give the ability for it to be a no-knock. In the case of the drug situation, if there's no if there's no evidence to show or reason to believe that it's going to be a violent situation or there's guns involved, you wouldn't necessarily need a no-knock warrant for that. You still get the warrant, but you'd give notice before you actually execute that warrant. And that's what we're trying to prevent here. We're trying to prevent these situations where you have these no-knock warrants and, God forbid, where there's been accidents and you're entering a home and you have situations where individuals that aren't actually engaged or aren't actually sought after, there's harm or death brought to those families. But this just raises the bar and it creates the procedural pieces to provide more transparency, which is what Ms. Gross was speaking to earlier.
And I see a hand up. I don't know who this is though. Oh, Michelle Gross. I'm sorry. Ms. Gross.
Hand things are kind of crazy.
Yes, I know.
Now I'm trying to take it down. It won't let me. But what I did want to, Chair Mariani and Chair Limmer, Senator Latz, I'd like to just address the question that you're raising. The main thing that this would do procedurally is bring police law enforcement administration into the question. It would require that these officers, rather than on their own deciding that a no-knock warrant was necessary, they would need to bring this before their police chief or their chief law enforcement officer to get that approval. It doesn't do a lot to change the court system. It changes it perhaps a little bit because the process for obtaining any type of warrant is for the officer to complete an affidavit and make a swearing in front of the judge. But this would put a step in between where there would be a senior leader, either the chief law enforcement officer or their designee, to review that that application. And that means that there's yet another kind of a step in there where there could be some reconsiderations about whether this no-knock warrant was actually necessary. There's enough danger to these warrants that we need that level of guardrail around them. Thank you.
Thank you, Ms. Gross. Representative Mueller.
Thanks, Mr. Chair. And I just wanted to talk for a couple minutes, not even a couple minutes, just address a couple of things that came up. And one was, do we need to define what possession is? And I know that possession with intent to sell is defined as a sale crime. But if you look at the different degrees of controlled substance crimes, they're actually broken into sales crimes or straight up possession crimes. So my understanding of the current language was that it just applied to those possession crimes, not the ones that were the possession with intent to sell, which is what we actually call a sale crime. And then I would also just say my understanding with the no-knock warrants, we have some requirements in statute currently regarding the time of day as to when a warrant can be executed, but there's nothing currently in statute surrounding the use of a no-knock warrant, and there's a little bit of case law on that, and I just can't remember off the top of my head what the cases say, but this is, I think, a really good way to put into statute what the requirements are, because again, we already have something in statute regarding the time of day for execution of search warrants.
Thank you, Representative Mueller. It certainly is a different bill than what was introduced. Really good work in terms of looking at, appropriate guardrails and, raising, the standards such as, what Ms. Gross, just shared. Really, looking to avoid, at least downplay, deadly force outcomes, while we're also honoring constitutional rights of folks in their homes. All right, members, so I'm going to move on to the next one. The next one is Travis's Law. This is carried by Jay Hansen in the House and Senator Abler in the Senate. It involves 911 or calls to 911 for crisis, and it directs that where appropriate, that those calls be referred to mental crisis teams to respond. And with us today is Flo Ching, who is the mother of Travis Jordan, who we tragically lost in an encounter flowing from a call that would arguably have been much better handled with a mental crisis team responding. Ms. Ching, welcome to the committee. It's good to see you again. Thank you for being here with us today, particularly as you continue in your journey of healing relative to your loss.
Thank you, Chairman. Hello to everyone, and my name is Florine Jordan Ching. Thank you for this opportunity to speak on my behalf. On behalf of my son, Travis Matthew Jordan, and his journey with mental illness. Travis was born and raised in Hawaii, where he grew up loving the ocean. His passion was surfing, boogie boarding. After a terrible accident in surfing, he was diagnosed with PTSD, bipolar, and anxiety. His disorder, he also suffered very serious health issues. On November 9th, 2018, 311 was called for a wellness check because he was experiencing his bipolar episodes. Instead of sending someone experienced in mental health crisis to officers with only 11 months on the Minneapolis police force were dispatched. They demonstrated no compassion or empathy towards him or his situation. This should never have happened. As Travis's mom, the pain and grief of the loss often knocks me to my knees. This has also devastated our entire family, his friends, and other loved ones. This was the most confusing and saddest day of his life. Please help us so no other family will ever have to experience this kind of pain. I thank you again and mahalo.
Thank you, Ms. Ching, and please accept our care and our love and concern for you and your family. And thank you for the courage of coming forward to make something good out of your loss and out of Travis's life that hopefully can intercede on behalf of many more lives. Thank you.
Thank you.
All right, members, we'll move to the last two bills. The next one is modifications to the body-worn camera policies. This was carried by Representative Thompson in the House and Senator Fata in the Senate. And we have two testifiers today. First, we'll hear from Deputy Commissioner, Department of Public Safety, Cassandra O'Hearn. And then we'll hear from Amity Dimmock, who's the mother of Kobe Dimmock Heisler, who we lost, some while ago. But first, Cassandra O'Hearn.
Thank you, Mr. Chair, members of the conference committee. My name is Cassandra O'Hearn, and I am the Deputy Commissioner for the Department of Public Safety. I want to thank you for allowing me to testify today on this provision. Commissioner Harrington and Superintendent Evans are unfortunately unable to join you this afternoon. The body camera statute in section 1382.5 went into effect about 5 years ago. Since then, the BCA has conducted numerous officer-involved shooting investigations, and we have learned a lot along the way. While video release is currently allowed under the statutory provision, there's nothing in the statute that offers consistency between cases or any certainty for the affected family members. This lack of certainty and clarity leads to confusion, and quite frankly, it lacks transparency. During the Deadly Force Encounters Working Group led by Commissioner Harrington and Attorney General Ellison, there was robust conversation about body cameras and the release of videos both in public testimony and in working group member deliberations. When Section 13.825 was drafted 5 years ago, we weren't in the same place that we are now. The inconsistency of video release between jurisdictions and even between cases is not effective in building or maintaining public trust. Governor Walz, Commissioner Harrington, Superintendent Evans, and I are all in agreement that addressing this lack of clarity and adding consistency in statute must be addressed during this session. I'm happy to try to answer any questions that the committee member may have, and I'll stay on to do so, but I also will listen and circle back with the commissioner on any questions and ensure that we get answers back to this committee. Thank you for this time to provide these comments.
Thank you, Deputy Commissioner, and thank you for your work in general and in this area as well. Yes, if you could hang around for a few minutes, I'd greatly appreciate it. Thank you. And so also on this provision, we'll hear from Amity Dimmock, who is Kobe Heisler's mother. Welcome, Ms. Dimmock. And as well with the other families, please know that legislators here extend their love and concern to you and your family as you journey through your healing process upon the loss of your beloved Kobe. Welcome.
Hi, everyone. Chairman Mariani, thank you for having me here today. As he said, my name is Amity Dimmock. I am the mother of Kobe Heisler. Kobe was the 21-year-old boy who was in the autism spectrum. And on August 31st of 2019, he had a bad day. His grandfather, who he lived with, called 911 because he thought my son was going to hurt himself, which he had a history of doing. And the officers who responded did know that. Because they were the same officers who had responded to a prior situation where he hurt himself. My son calmed down instantly, so the grandfather called 911 back and told him everything was okay. The officers chose to come anyhow. When they got there, it was clear that everything was okay. They snuck up on the house. The grandfather saw them coming up through the window, so he came out and once again reiterated that everything was okay and that they weren't needed. In fact, the grandfather even said, if you go inside, you'll probably, escalate a situation and they didn't listen to the officers, went into the house anyhow. And keep in mind, this is like a 75-year-old couple. They don't know like how some of us do now. Don't call 911 in an emergency like this, call 311. They don't know these things. And I think they also don't know that maybe they could have been a little more strong about telling the officers, look, I said, don't go in my house. Like, you're not needed. We told you you weren't needed. Nonetheless, they went into the home. They searched my son and put him down on a chair in the middle of the room, even though, he wasn't charged with anything. He hadn't done anything. But nonetheless, this 21-year-old autistic boy somehow complied with them the whole time for 12 minutes while they're actually trying to get him to admit to doing something. And people on the autism spectrum, well, if you harass them long enough, will sometimes just tell you whatever you want to hear. I'm not going to get into the whole story. I see Michelle looking at me. I'm not going to get into all the specifics of the story, but the bottom line is that they came in, and after 12 minutes of my son complying with them, and literally a second before he gets murdered, you just see him put his hand down on his hands because he was just so over it. He just wanted to be left alone, and he just starts crying. And then he gets up to run. And what you can't see in the video is he was simply trying to extract himself from the situation. He was trying to run outside the house. Where he was running would have done that, but the officers knew that. And they ran around the other way. And they stopped him, and literally within it's like 3 seconds, he is tased and shot multiple times, including in the head. in his own home in front of his family, where a person is supposed to be the most safe, in a home where they told him not to go in. How dare they not trust the family over the officer's assertion of what was going on? They didn't know. They didn't know my son. Everything was going to be fine. Everybody would have been fine if they would have listened. And then the worst part is to have the Brooklyn Center or the Brooklyn Park Police Chief tell me if my son would have been murdered there, he'd be alive today because they would have handled it better. So this stuff where we're doing it, one little city here and another little city there, doesn't work, because you shouldn't be able to survive an instance in one city and not the other. I am here to testify, though, on the 48-hour bill, because, and I invite any of you to just really put yourself in my shoes, like 100%, and imagine that it's your kid and that this is what I have to do to try to get people to do what's right. Come and tell my story and re-traumatize myself every time. And half the times doing it, not even believing that the people I'm going to talk to are going to do what's right, because I have talked to a lot of you on here already. And nothing's been done. For Colby's 48-hour bill, all we're asking is for the next of kin to be able to see the body cams and audio within 48 hours of a police murder. And I think if any of you were in my position, you would want that instantly, but at the longest 48 hours. And now we are seeing, and as somebody else mentioned, how it's not like continuous, it's not consistent, and it shows a lack of clarity and not transparent at all. So I can't get my video until literally Mayor Mike Elliott called us 4 days after George Floyd's murder. That was over 10 months with nothing. And I'm out here trying to speak on behalf of my son, but nobody will give me any information. So who knows, maybe I sound like an idiot out here saying one thing, but they won't give me the video. So me, the mother who birthed him, can know what I'm talking about and know what happened and see it with my own eyes. Now then, on top of that, I have to wait until after George Floyd gets murdered. And we know that if George Floyd hadn't gotten murdered, that Mayor Mike Elliott and Chief Gannon would not have called me and offered me those videotapes at that point. But then Dante Wright happens and George Floyd happens after my son's murder. But hey, you can go right ahead and produce those tapes right away. That's not fair. And it's not fair as a mother of a case that's not out in the public, one of those household names. It just feels like nobody cares. And like, I'm over that. I also have a few other just side notes. On the union, I think what we really need officers to understand is that the union is there to protect the right doers also. So let's stop thinking that the union is only there to protect the people who we think do wrong, and then they keep them on the force. The union should also be there, and these officers need to know that they can be there to protect you when you call people out. The union's there for the bad and the good. So let's remember that. I also think that if, at this point, if we can't just figure out more, like something that's fair for us families, how about we just make it so every police murder automatically warrants a jury by our peers? Because I'm sick of what seems to be politicians making decisions about whether or not our cases get a fair trial. My son was in his own home on a reverse 911 call, but because we can't get enough pressure for you guys, we can't get the turnout, and we clearly see that huge turnout makes the difference. So we saw that in the Dante Wright case, and we saw that in the George Floyd case. Well, guess what? That's not right, because not every family has that ability, and not every family has a tape, and not every family was able to catch it on live. But you know what happens? We get treated different. There's a different set of laws for what's out there and what's not. And so, as Tashira mentioned before, there's 470 police murders in the state of Minnesota alone in just 20 years. And you all can probably name 5 of the names. And my son was the most beautiful boy in the world. It was the first love of my life. And he did not deserve what happened to him. And then we also have to sit back and have the police make up a story and then have every time, which, you know, they say he grabbed a knife. How? That kid wasn't even delicate. He was the clumsiest thing in the world. You're going to tell me he somehow turned into some superhero and could make all these moves that they're claiming? No. But the 48-hour video thing, I have a right to see what happened with my own eyes, so that when I'm dealing with all this stuff that I've been dealing with for the last year and a half, I know what I'm talking about.
Thank you.
Thank you for listening.
Thank you. Thank you, Ms. Demick. And again, please accept my condolences and my sincere thoughts and expressions of love and concern for you. Please know how we can continue to support you, and thank you for the courage to come forward through your pain.
Can I just say one more important thing?
Yes, please.
It's on the mental health bills. I really think it's important that police don't respond to mental health calls at all. And I think one thing that people kind of forget is that when we send those professionals in who are trained, these are like 8 and 10-year college grad people dealing with these sorts of situations. I think the one thing people forget is once those professionals get there, they still have the ability to call the police if the professionals determine it's needed. But do not send the armed officers first. It will never turn out good.
Thank you. Thank you for your advice. Members, the last bill in the...
Mr. Chairman?
Yes, Senator Latz.
I'm sorry, maybe I'm not clear on the protocol here, but I'm not hearing any description of the provisions of the proposed legislation from many of the testifiers or from staff ahead of time. Are you anticipating that we are reading the language in the bill at the same time, or are you intending to deal with details at some other time? Do you want to have conversation or discussion about any questions about the details now or later? I guess I want to respect what you're intending to do with the hearing, Mr. Chairman.
Yes, of course.
As to how we are supposed to proceed to analyze the House proposals.
Yeah, Senator Latz, of course, and we have stopped when members have asked questions and have turned to counsel to provide some guidance, and we could certainly do that with this. And actually, this one would be a good one because this bill has also changed quite a bit, particularly around the conditions for the 48-hour next of kin reference. There is what's the right word for it? There is an exception to that in order to honor legitimate needs of law enforcement, particularly in investigations. And so let me just quickly turn to our counsel to do a brief description of this particular piece. We have a lot of bills that we want to propose, that we're proposing here. We certainly do expect our members to read the bills, but we also know that it's important for us to spend the time, as needed to be able to dig through those. What the chair wanted to do today was to really get across to all of us the importance of acting, because one of the big messages that we've been hearing is that we shouldn't act, that somehow, an omnibus bill is not a time for us to act on pressing policy issues. And so quite frankly, and quite openly and honestly, I wanted to make sure that we're hearing the voices of Minnesotans in terms of this desire to act. But let me turn to council very quickly relative to the House file or the House language relative to 1103, which you'll find in Article 10, pages 12, R12 through R14. It's on lines 129.1 through 130.12. And let me ask them to do a very quick description of what that is for us.
Mr. Chair, this is Jeff Diebel. The provision in this on this topic is modifying the model policy for body cameras, and it's the requirement that any agency that deploys and equips their officers with body cameras must have a policy. And this sets out additional requirements that must be included in that model policy. And those requirements include retaining the copy of the unedited copy of the film, including metadata related to that film, in a manner that's consistent with the data retention requirements set forth in Chapter 13. The other provision we've discussed is the 48-hour in a deadly force instance. And in a related note, the retention requirements in Chapter 13 would not apply to the deadly force video recordings. Those under this policy would be required to be retained indefinitely. The 48-hour disclosure is for family and representatives of persons who are killed by police. As you mentioned, Chair, there is an exception if law enforcement, the chief law enforcement officer believes that it would compromise the investigation. They can deny the request to view the video within 48 hours, but there is language there providing guidance as to how the chief must provide guidance to the party if they deny their request as to how they can appeal that decision. And then finally, the additional requirement that must be added to a policy is that any death as a result of the use of force by a peace officer, the video recordings must be released within 90 days of the incident.
Thank you, Mr. Debo. And again, Sarah Latz is part of an offer. Absolutely appropriate for the Senate then to receive that offer and then come back and respond in a number of ways, including, hey, we need much more information. We'd like more testimony. We propose this, this particular approach. That's the give and take, of the process, as you know well, because you've been around almost as long as I have in the legislature. But that's, this language before us today is being offered within the context of an offer that the House is putting forward to the Senate.
So, Mr. Chairman, as the chair knows, the likelihood of me as the minority member of the Senate Conference Committee being included in the discussions and analysis and evaluation of the terms of a counteroffer or the details of any proposals made in a counteroffer is fairly low. So I think my opportunity to elicit information is probably going to be in these public hearings. I do have some questions about this particular provision. As the chair may recall, I was the chief author in the Senate of the body camera legislation that even put any guardrails or guidelines around the use of body cameras when the statute was first put into place. And it was intentionally left a bit broad as we allowed local units of government to develop their policies, and as we had more experience across the state with the use of body cameras. I think it was anticipated that there would be some follow-up after we gained some of that experience to see if there were any statewide basic policies that the legislature and or the post board would feel be appropriate to bring forward. And so I think it's appropriate that we are reviewing some of this. I do have some specific questions about the way this is proposed to work, and I'm happy to hold off on those questions at this time so that we don't get too bogged down in the details. I'm cognizant of our limited time here, and I will echo what Representative Miller said yesterday, that in order to do justice to the quantity of policy being proposed, 3 hours a day is woefully inadequate. So I guess maybe I will leave it at that and hope that we can get some meaningful responses on offers that can put some of these discussions of more detail on the table for us to work through particular language questions and so on. But I do think that we're going to need some more time to be able to do this meaningfully as well. So I would encourage the chairs to seek that time from the legislative leadership. Otherwise, I fear the lack of time could simply become an excuse for inaction, which would be inappropriate in my judgment. So I guess I will leave it at that, Mr. Chairman. Thank you.
I concur with you, Senator Latz. Thank you for your wise and experienced advice. Members, the last bill then is Matthews Law. Was carried by Representative Quam, a GOP member of the House. And the Senate companion is Senate File 304, carried by Senator Senjum. And quite simply, this bill addresses the use of confidential informants by law enforcement. Matthew was an individual from southeastern, small town, southeastern Minnesota that had become a confidential informant for all the good reasons. He really wanted to give back and clean up himself up. He unfortunately was put in a position where the temptation to use again, he had been addicted, became part of his reality, and he died as a result of that use. And this is a bill that actually has strong bipartisan support. It's moved off the floor. I think perhaps the Senate moved it off the floor. I think that's right. And it would develop a comprehensive model policy at the Post Board with learning objectives to address the use of confidential informants by law enforcement, accompanied by accompanied by training for those standards. The standards basically then would be focused on protecting the rights and the well-being of informants. And so, yes, I'm noting now that in fact this provision has passed off the Senate floor. So members, that concludes the.
Chair?
Yes.
Sorry to interrupt you.
No, all right, Chair Limmer.
The Matthews Law provision did in fact pass 66-0 on the Senate floor. I believe it's on the House floor. And once again, your chamber could pass it out and get it to the governor's office, maybe even later this week. So, since it passed with such uniformity and kind of global application, I would hope that it would pass the House equally as well. So that's one that we could actually pass out individually. Just wanted to bring it to your attention, Mr. Chair.
Well, Chair Limmer, I actually agree with you. I hope that happens. As a veteran of this legislature, you know a lot of funny things happen on each of our floors, and hopefully that will be the case. I think yet another good reason for the Senate to accept this offer. Provision that they have unanimously supported. I think it reflects, quite frankly, a goodwill on our part to put together a good, balanced, common sense set of proposals before us. All right, members, so that concludes the walkthrough of the more specific about these provisions. You heard the hurt and the pain of a diverse group of Minnesotans. We heard more than that during the course of our extensive hearings throughout the previous 4 or 5 months. There is certainly a case to be made that harm is happening, and the question before us, I would submit, is that avoidable? And what can we do to make our systems better? How do we use good social science and studies and experience and expertise to inform us on how to do that? And as I said at the very beginning of this hearing, the House has several provisions. There are several in this offer that we are about to make. I would love it, absolutely, if we can agree on all of them. My experience tells me that that's usually not the case. But I do think that we don't have to agree on all of them in order to take the steps that we think the House thinks that the people of Minnesota wants us to take. And so taking some steps are preferable to taking no steps. And so please accept this offer as an invitation from the House to the Senate on taking action and taking important steps. And we look forward to hearing your responses to them. I'm going to ask Representative Frazier to then summarize and officially forward the offer to the Senate at this point in time. Representative Frazier.
Mr. Chair, thank you. I mean, I will just right up front, I'll make the official offer. This is our offer. We expect and we hope that in this moment, in this instance with this offer, that we do receive a counter or just an outright rejection or just some response. Just my observations, and I'll summarize because I know we don't have much time. Ms. Demick was right. Every time we have community members come and share these stories, they are re-traumatized. Every time we have a killing in our community, the community is re-traumatized. I think of it like this, and I'll paint a picture. Imagine that we are a team of firefighters sitting outside a burning building. We got the fire hose, we got the fire truck, we have all the tools to put that fire out. But we look into the building and we see the people trying to get out of the building, asking for help. They're in a burning building. And we give them our thoughts and our prayers. When those that have the power to act, put laws in place, put policies in place that can actually change and save lives, our thoughts and prayers mean nothing to those individuals when we don't actually act. We have bills in front of us. On the House side, we spent the entire session listening to individuals, listening to community members, listening to grieving family members, listening to grieving and traumatized community members. And we've taken that grieving, we've taken that pain, we've taken that trauma, we put it into these bills to provide something, to provide some relief, to ensure that this doesn't continue to happen to our fellow Minnesotans. Now we're at this point. Now, it's unfortunate that the Senate hasn't had any hearings on these bills. And I am frustrated like Senator Latz, because that would have provided opportunity for these bills to be thoughtfully heard, to considered, things to be hashed out, questions to be asked. And just maybe we would have came to this point and we could have moved quickly to actually accept these bills, move forward and get them passed into law. But that's not where we are. But now we're almost a week in and we cannot continue to waste time. We cannot continue to fall back on procedural arguments or some type of history that is not codified and say, this is just not the time to hear policy bills. It is always the right time to do the right thing. And this is that time. And this is that moment, because there's still a spotlight on Minnesota. And there used to be a time that Minnesota always wanted to be the leader. I am hoping that this is going to be another one of those times that we will be leaders and we will do the right thing. Because I got to tell you, just like some of the testifiers said, the more inaction that we have from our legislative body, the more these communities continue to feel devalued, the more they continue to feel like their lives don't matter. We have to make sure that we take the actions necessary to show them that their lives do matter. Thank you, Mr. Chair.
Thank you, Representative Frazier. So with that, I'll open it up for comments, thoughts, reactions. We've got a little bit of time. And if not, we can certainly adjourn early. Chair Limmer.
Thank you, Chair Mariani. I want to thank you and those, the guests that gave testimony today. We had a very eye-opening, respectful discussion. I want to thank all of those, especially family members who had to open up their hearts again to the circumstances that got them here. We're listening carefully. And as I look over the list, we will be focusing on this. As you know, the bill before us is much larger than just the police issues. It also includes the budget, DOC, Department of Corrections, some court issues involved in it, as well as some other freestanding, various other issues. So we will be considering your proposal in the next day or two, and we'll hope to be getting back to you on that. But I want to thank you for the opportunity for this hearing and to listen to the guests that you've provided for us.
Very well. I appreciate that, Chair Limmer, and I do appreciate the rapt attention and engagement of all our conferees as well. Quick question, you've got the gavel next. Do you have any plans for us in terms of meeting on Friday?
Well, to begin with, tomorrow we'd like to finish with Commissioner Harrington. He seemed to have brought out a lot of interest on behalf of our membership, so we'll be moving in that regard. And I'm getting the signal that the VSET issue is one that we'd like to bring up. And then we'll be adding, if we have time, we'll be adding a little bit more, but we'll let you know that ahead of time.
Very well. Thank you, Chair Limmer. And I'm encouraged by the day or two response in terms of this offer. The Senate, or rather the House, certainly is interested in meeting again on Saturday. Sunday is verboten. We can't do that, but you and I can always certainly be on a phone call together.
One thing I might suggest, Mr. Chairman, this second offer, the 12 items, I was only made aware of this about an hour before today's committee. So if it might help to give us a little more lead time so that we could be better prepared for a discussion in the future.
We'll certainly do the best that we can on that. Absolutely, I don't think that's unreasonable. And again, you know, we do expect a counter offer. I mean, that's how these things get built. And I'm again encouraged by your response that you're looking to do that within a day or two on this. All right. Well, Chair Becker-Finn.
Thank you, Mr. Chair. And I'm relatively new to working with most of these conferees, and I just want to say that I really do hope that both offers will be taken seriously and that we can get some actual responses so that we can then respond in turn and to move things forward. I came to this job to do work and to get things done. And I really, you know, hope that goes for everybody else too. And if that means, you know, digging in and doing our homework and reading things and getting up to speed. I know it's a lot to do, but I just am really hopeful that we can reach some agreement, because I know I didn't chair a committee for 4 months to not get anywhere at this point in the session. And so I welcome any questions. I also just want to note there are a lot of really good things where we have bipartisan support that came from the judiciary side of our bill. And I hope that we're all remembering those things as well, in the limited time that we do have with our 3-hour-a-day meetings. But just wanted to bring that up because I've heard comments today, this is too small in policy and it should happen a different way. And then hearing, well, we haven't heard these things. So it's, it feels like it's got to be one or the other. Either we fully knew about it and we voted on it, and, there's sort of an inability to include those things. And then these are brand new things. And we're also, not sure that we can move on brand new things either. And I hope that we can sort of set that aside, look at good policy, look at good work, and see what we can do for all of our constituents, and look forward to continuing to have those conversations with all of you. So thank you.
Very well. Anyone else? All right. Well, members, these hearings are often tough, particularly when you're interacting with, real pain and harm that's been done. And hopefully we can be part of responding to that. To Chair Limmer's point, there's a lot that we cover in both of these House and Senate compilation of committees. And so we just really addressed one big, albeit big issue today. But there's so much more that we're going to need to work on. And so again, my appeal to all our members here is that we be expeditious in responding to offers to one another, so that we can construct this bill, because there's just so much that needs to be covered. Judiciary, corrections, all the standalone boards that we have. Corrections alone is one of the largest state agencies in our state, and so we need to make sure we're spending good time on those issues as well. And of course, Chair Becker-Fenn, our courts aren't small matters either. And Senator Matthews, no doubt, data privacy and civil law issues will certainly fill up a large auditorium at any given point in time. So, Senator Limmer, we'll look forward to notice about tomorrow's meeting. And as I said, look forward to your the Senate's counteroffer in the next day or two. All right. With that, members, then this conference committee stands adjourned.